Hi, good morning. My name is Antonio Flores. I'm working for Lawbird, and this video blog we are filming today is for the purpose of customers who bought from Torrevisa on the development named as Golden Sun in Pulpí in Almería. I have a number of items here which I will be running through, and I'll be dividing them in 3 blocks. I don't want to make this too long. I want to make it rather short so that you understand what the position is. We'll start with the overview. Torrevisa, we are aware that has applied for company voluntary arrangement, which is like an insolvency procedure, inviting anyone who has paid money to join the creditors list. Some blocks have been finished, and the license of occupancies have been achieved, have been granted by the town hall, whilst others haven't. On the ones where the licenses have been achieved, the developer is suing for termination of the contracts. Now, it's important that you understand that as far as we are concerned, as far as we know, the developer is not suing for fulfillment of the contract, but just for termination. What does this mean? Well, this basically entails that they want to keep the money and not pursue you any further. For the blocks which have not been finished, clearly the developer has not been able to do anything, and they are hoping that you will not enforce the bank guarantees which are available, at least for some buyers individually, but also there is a collective bank guarantee, which in our understanding, property buyers should be able to claim on. Now, as far as the customers which are being sued, we have a different opinion than other law firms who are dealing with these cases. The first of all is that, as I said before, the developer is not suing for performance or fulfillment, but for termination and compensation up to the amount of the deposit paid. Okay? They have not requested any more than what people have already paid. There have been already 2 rulings which we know of where the same courts which will be dealing with these civil suits have indicated that lack of formal notice of cancellation on the one side, and 2, the real not relevant delays in delivering these properties cannot make up for a case of termination on the side of the buyers. So buyers, what the courts are saying is that are not entitled to pull out, because what we say is that the developer has effectively completed. Now, you might be thinking, well, they have completed and achieved license of occupancy, but the whole place is a mess. That is true, and that is what we think should be the opposition ground when opposing these civil suits which are being brought by the developer. Now, also, we have a different view to that of other lawyers. Some other lawyers are indicating that you are entitled to receive 50% of the sums back which you've paid in the event that the developer terminates. Now, we've read the contract, and it doesn't seem to indicate that's the case. What Clause 5 of your contract says, and I believe you have it in English as well, is that the seller shall retain 50% of the amounts the purchaser should have paid on the date when the seller opted to terminate. Now, our interpretation of this clause is that the developer would be allowed to retain up to 50% of the full purchase price, because we understand that on the day of them terminating, the full balance of the purchase price should have been paid, and therefore what they say is that they would be entitled to 50% or up to 50% of the sums which you should have paid on that day, which is half of the purchase price. Now, the developer's not doing this. What they're saying is, we will only keep the sum of money which you've paid us due to your breach of contract or failure to turn up at the notary and complete. Now, there is another interesting and important item which has come up today. We have noticed that the service of process, in other words, the document which you was sent by the lawyers, when I say you, I mean a number of customers only, where you are given 10 days to submit your answer, has some procedural mistakes. We have called the courts in Alicante and we have pointed out this mistake. Why we think there's a mistake? Well, basically what they are saying is that the courts should send a translation of that service of notice to the customers because they believe that the customers are not being represented by lawyers. Now, the customers we are dealing with so far are represented by lawyers, and therefore this clause would not be applicable, in which case for people who had 10 days running as from the 1st of February, the 14th would be the last day if we take out the non-working days. Now, the courts have said over the phone, over the phone we mean that they will be resending this service of process in the next few days, and therefore they will give another 10 days to the people who received these notices so that they can then oppose or file a motion to object to this civil suit, which is actually good news because today that means that today would not be the last day. That would only apply for those customers who received a service of process and there was a mistake on them because it confuses. The court has realised that there is a confusion and therefore it needs to be resent. Now, we think that in order to avail of a larger degree of protection, we believe that the lawyers should not be taking on the writs. In other words, they should refuse reception of those writs, of service of process. Why? Because that way the court will have to then resend them again or try to find a new address for notifications. All the while you are winning time to find ways to object to the developer's lawsuit. Now, we think that the general condition of the development is not good enough for people to live in it because there are blocks which have not been finished. The place doesn't seem to be correctly finalised, and therefore there might be grounds there to oppose. What we would also like to say is that this court in Alicante seems to be predisposed, according to 2 rulings already, to give the developer the right in this dispute. In other words, to produce a ruling stating that the buyers were the ones who failed to complete and not the developer who failed to complete on time. We do think, however, that there are certain grounds to oppose this, not many, but for the people who had their properties finalised and the licences granted, we feel that we need to have a report done on the development. We need to have a photographic evidence of how the place has been left and therefore use that to counterclaim. Right, now to conclude this video blog, we'd like to invite people to basically make a decision in respect of which law firm they wish to engage to deal with these cases, because different lawyers are going to have different opinions. That is natural, and it was also actually advisable, for different ways of seeing the same thing. We have a certain strategy which we would like to implement. Therefore, if you do wish to join us, you can certainly do so. We will be sending an email explaining more in detail how we see the way forward in respect of the civil suits which are being received and those ones which will be received in future, but also not less important for people who had their properties unfinished, the legal recourse they would have against the bank, which is Bank Caja, which did guarantee a number of individuals who bought in this development and therefore have an obligation, according to case law, to provide cover to everyone else who would have bought in that same development. Thank you very much.